What do you need to do to have an effective plan with regard to your real estate so that you're not bumping up against estate tax issues? The second thing to consider with regard to how to deal with your real estate in your estate plan is how you structure ownership. And it's very common, I hear all the time, well, I want to do my estate plan. I want to put my kid on my house so they don't have to go through probate later. And so there's different types of ownership structure. And we even did a partial episode, I think, about that. It's not great. So there's a few different ways to structure your real estate with regard to your estate plan. The first thing to consider is joint tenancy. Property held in joint tenancy with right of survivorship, while it avoids probate and passes to the joint tenant, joint owner, when one of the joint owners dies and avoids probate because of that, it's an operation of law, it has some downfalls.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth. Pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning and probate attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning is often a confusing and complicated topic. My goal with this podcast is to make it understandable and accessible to those who need it. So if this is something that interests you, I'd appreciate if you click the subscribe button, like this episode, so that you can follow along as we break down the barriers to estate planning. I'm excited to get to today's topic. Today's topic is real estate considerations, the impact of multiple properties on your estate plan. Because real estate is likely one of your most important assets, and possibly your largest asset, and maybe one of the most complex in dealing with your estate plan. So on today's show, we're talking about real estate considerations, the impact of multiple properties on your estate plan. So let's get to it. Real estate is often a significant component of an estate plan. Whether you own a primary residence, a vacation home, rental properties, or investment real estate, it's crucial to understand how these assets reflect within your overall estate plan and how they affect your estate plan. How you deal with your real estate has a lot to do with how hard it will be for your executor and heirs to deal with everything when you're gone, and potentially while you're still alive if you become incapacitated. So a few weeks ago, we talked with Realtor Nick Lind about how to treat your real estate as an investment and the importance of using a realtor and having a good realtor on your team of advisors. And so I thought it would be important today to follow that up with how these issues related to real estate affect someone's estate plan. And so we'll get right into it from here. So the first thing to consider with regard to your real estate and its effect on your estate plan, or how it fits into your estate plan, is what it's worth. What's it worth? So we want to have accurate values, accurate property valuation of our real estate. We should have periodic appraisals, or at least talk to your realtor about a broker price opinion with regards to what your properties are worth, because the market value of your property is what is determined as far as how much that property affects your taxable estate. And so since these values fluctuate over time, you want to be aware, right? Even looking at a website like Zillow or Redfin or something like that, though not exactly perfect and not exactly correct all the time, can give you a rough idea of what your estate's worth, real estate-wise. I meet with clients all the time that say, well, I think my house is worth $300,000. That's what the county said. I got my tax statement in the mail. And usually that's wildly lower than what it's actually worth. Just over the last 4 years, since 2019, the median home price has increased 46%. So if you bought your house before 2019, imagine what it's worth now. right? And so you want to make sure that you take a look at that every once in a while at least, right? Maybe even just look it up on Zillow. And that leads to how that asset, that real estate, is going to affect your taxable estate. The total value of your estate, including all real estate, determines what your estate tax value is for federal and state estate tax. And here in Washington, we have a state estate tax, unlike many other states. And so the exemption that you get for that is affected by the value of your real estate. You don't get an exemption for, well, you've got a house, so you don't have to count that. That's part of your taxable estate. And so accurate evaluations of your real estate is critical to determining how you move forward with an estate plan. What do you need to do to have an effective plan with regard to your real estate so that you're not bumping up against estate tax issues? The second thing to consider with regard to how to deal with your real estate in your estate plan is how you structure ownership. And it's very common, I hear all the time, well, I want to do my estate plan. I want to put my kid on my house so they don't have to go through probate later. And so there's different types of ownership structure. And we even did a partial episode, I think, about that. It's not great. So there's a few different ways to structure your real estate with regard to your estate plan. The first thing to consider is joint tenancy. Property held in joint tenancy with right of survivorship, while it avoids probate and passes to the joint owner, when one of the joint owners dies and avoids probate because of that, it's an operation of law, it has some downfalls. Okay. What happens if your joint owner gets sued by somebody? What happens if they get divorced, right? What happens if they owe somebody money and they just can't get it, right? That could affect your property that you're joint owner on. And maybe it was your property to start with. So you don't want to add a joint owner necessarily just because you think it's going to avoid probate. It doesn't have the protection of the trust. What happens if you pass away and the joint owner's in the middle of a divorce, or they're in the middle of a lawsuit? Maybe it's not affecting you directly yet, but maybe you pass away and they get that house. And so it's open to the divorce. It's open to the judgment even more. So, okay. So it can put the joint owner in a bad situation. It can put you as the person creating the ownership structure in a bad situation. So it's not optimal. The most common way people own their real estate is a tenancy in common. And that means that each tenant owns a specific percentage of the property. If it's a husband and wife or a married couple, they typically own 50-50. And that can be bequeathed to their heirs through a will. And you can have multiple owners in a tenant in common situation where there's no operation of law transfer. You can have as many owners as you want, but having those owners doesn't help avoid probate. There's no trigger when someone dies. There's no right of survivorship. And so that still has to go through a probate situation. And you still have the same problems, like if someone gets in a bad car accident and gets sued or gets divorced, the whole property's on the hook for everybody else too. So another way to hold property, the most common way to do it, if it's a married couple situation, husband and wife own that property, or a married couple owns this property, then that's typically one person, right? That's basically sole ownership because it's community property. And that means if something happens to one of them, it happens to both of them. So there's no real inherent risk there of having a spouse's own property together. The other way to do it, so if you're going to do nothing, just do nothing, right? It's better than having joint property problems with someone getting a judgment that's a kid or a friend or whoever this property is going to. It's better just to hold it by yourself or with your spouse. And so these properties typically go through probate, which is better than having a judgment come against you during your lifetime. But that can be avoided through use of a revocable living trust, which can streamline the process and avoid that whole probate nightmare, which we've talked about in detail on this podcast. And so the sole ownership avoids the joint owner problems that we talked about. The trust avoids probate and can help the beneficiary. So going through probate can be a positive for a beneficiary because sometimes the distribution can be dictated in a will or a trust that says, well, hold it in trust for them, or hold it if they're in a bad situation, don't give it to them, right? That kind of stuff can be written into your will or your estate plan. Through a trust, you can also create, or a will, you can create a trust for the beneficiary that would hold property, that would protect that from creditors, or if they have special needs, protect them from losing their benefits. So there's lots of different ways you can sort of structure it if you do it through your will or trust. And with a trust, you could avoid the probate process. Number 3, Estate and gift taxes. We want to consider estate and gift taxes like we talked about before. That's why we want to value our properties semi-regularly. And both the state of Washington and the U.S. government have estate taxes. And states like Washington have a lower exemption than the federal exemption. Our exemption here in Washington is $2.193 million per person, whereas the federal exemption right now is $13.61 million per person. And so most people aren't worried that much about the federal exemption right now, but the state is very low, which we've talked about. If you have a house, and the median house is in the 600s, I think, in Washington State, and if you're in Western Washington, it's higher, probably. You need to consider that, right? With that $2.19 million, if you've got your 401k and you've got your investments that have grown over time and all of that, you want to make sure that you're watching the value of your estate. And you can do some strategies to reduce the value through estate planning, creation of bypass trust, credit shelter trusts, which are usually part of a revocable trust. You can also make gifts during your lifetime of properties to reduce the taxable estate value that you have. You can use your annual exclusion, which is something that's on the federal side. Washington does not have a gift tax. It only has an estate tax. The federal government has a estate tax and a gift tax. They're unified right now under unified credit. So you can either die with $13.6 million or you can gift it away during your lifetime. And so you can make gifts of any amount up to $13.6 million with no tax. But you can also gift under something called the annual exclusion, which right now is $18,000 per person per year. You can gift $18,000 per person per year without eating into your gift tax credit under the federal gift tax. And so that's a way to potentially reduce the value of your taxable estate. And we'll get into that a little bit later here as to some entities. Another thing to consider about real estate in your estate is liquidity. So liquidity considerations are important. What is liquidity? That means I've got money in the bank, right? If your estate is mostly real estate and you don't have a lot of cash or a lot of assets that can be liquidated easily, like stocks or bonds, things like that, and it's just real estate where you'd have to sell properties to get cash, you need to consider that, right? So real estate is typically an illiquid asset, making it difficult typically to convert it to cash. And so you want to make sure that you've got some liquidity. So maybe have some other investments. Maybe have, CD, life insurance as liquidity to your estate. Well, it sometimes increases the value, but you can structure it properly. So life insurance is a good way to go, oftentimes, to add liquidity to your estate if you don't have a lot of liquid assets. And so this liquidity is important, especially if you have a taxable estate, because you have to pay the estate tax. And so if you don't have the ability to pay the estate tax with cash, you know what that means. You have to sell the real estate to do it. And you may not want that real estate sold. You may want that to be your legacy for your family or your beneficiaries. That's why things like life insurance, other types of investments, ensure that you have the sufficient liquidity that you need in order to cover those liquidity issues. Also, when someone passes away, whether it's a trust or a will situation with a probate or a trust administration, there's often going to be fees. You're going to have to pay bills. You're going to probably have to pay a lawyer in many cases to help. And, there needs to be some cash there. So just having no cash and a bunch of real estate doesn't really help. Number 4 thing that we're talking about here. 5? I don't know. I'm not sure. Another thing to consider, regardless of number, is the use of trusts in your estate plan. So there's 2 types of trusts we'll talk about here. Revocable trusts, which is the most common style trust, revocable living trust. That can hold probate. You're in charge of that trust. You're the grantor setting it up. You're the trustee in charge. You're also the beneficiary. These types of trusts can hold property and allow you to maintain control during your lifetime. And then upon your death, those trusts allow real estate to transfer to your heirs without going through probate. Irrevocable trusts can be created during your lifetime. And these trusts are usually created in conjunction with a gifting plan, where you create an irrevocable trust, you gift assets to it, maybe you gift a piece of real estate to it in this scenario, and it can reduce your taxable estate because you're getting that real estate out of your taxable estate and protecting assets from creditors. That can be a positive about irrevocable trusts. But the problem with an irrevocable trust oftentimes is you're relinquishing control, because if you want it to be an irrevocable trust where that asset is not part of your taxable estate, You can't be the trustee of the trust, and you can't be the beneficiary. So you're basically giving it to your beneficiaries early for them to manage and hopefully be able to manage properly. And that also leads us to some other entities to use. Another popular entity to use with regard to real estate is a limited liability company. And a limited liability company is basically a company, right? It's a legal business entity. And it allows you to put rental properties or any kind of properties, other assets as well, investments as well, into these entities where you own the entity. You have control. You're the manager typically to manage it. But it adds some liability protection. So if something happens inside, so say for example you have a piece of real estate that's a rental property, and you place that rental property into an LLC. If something happens on that rental, typically liability is focused only on the LLC asset, which is the house or rental property, and not on your other assets. And the alternate is also true. Assets from the outside, if you had some liability from the outside where you had a car accident or you got sued by somebody, the LLC can provide asset protection for the rental property from the outside creditor trying to get in. Use of a limited liability company can reduce your liability, and it can also work with a conjunction to the gift plans that we talked about before. You can make gifts annually under this annual exclusion and sort of reduce your estate by gifting units in this LLC versus gifting like a whole property or just interest in the asset. And by having it in an LLC, you maintain control in most cases. So that's a good plan typically with regard to reducing your estate, maintaining control, and having some asset protection. Next thing, maintenance and management plans. So if you have rental real estate, you should have detailed property management plans for who's going to manage the property and maintain them while you're gone, right? This is critical for rental properties, especially ones that require significant upkeep. And in conjunction with this, you want to have a competent executor or trustee who understands your wishes and can manage these properties effectively. In most cases, if you have a rental property, not everybody, I guess, but a lot of people use a property management company, and they sort of do the day-to-day. They collect the rent, they find the tenant, they make sure that the property's water pipes, if they burst, they get somebody out there, right? But not everybody does that. And so if that's not you, make sure that you have someone that can help you with that when you're gone in charge. And you want to make sure that if you want to have that rental property as part of your beneficiary's estate later, or if you want them to be able to benefit from that property, having a detailed maintenance and management plan is important. Another thing to consider with regard to real estate and how it interacts with your estate is equalization among heirs. So say, for example, your estate is real estate heavy, right? So you've got a house that's worth a lot of money. You maybe have a rental house or something. You maybe have a vacation house or a cabin, I don't know. And you don't have a lot of liquidity, okay? And so if you have multiple beneficiaries, you need to consider how you are equalizing, and you're trying to equalize distribution or balance distribution. You don't have to give everything equally to all your kids. That's not a law or anything. But it's probably the most common way people distribute their estate. And so that have multiple kids, they typically give that estate equally to their kids, most cases. But not everybody does, and you don't have to do that. And so you really want to consider how you can distribute among your beneficiaries in an equitable way. And if you have multiple properties, or maybe you'll just have one property that you're keeping, you need to consider how to do that. And one approach you could do in your estate plan is to say, well, if I have all these real estate pieces, sell them and then distribute the proceeds. Okay. And so you could do that. That's a common approach. I'm not a huge fan of that, saying, hey, sell the property and distribute it. I guess I should back up. I don't really care if you say sell the property. I don't really care. But I don't really like it when it's a requirement, okay? We don't want to make it so that the trustee says, you have to sell this property within 90 days of when I die, or 60 days or 100 days or whatever. We don't want to give them a time limit, because the problem with that is there could be a terrible market condition. It might be a terrible time to sell a property, and if the trust says or the will says sell the property within 90 days of my death, you could really lose value to your heirs, right? Really lose it. And what happens if a beneficiary wants the property and the other beneficiaries are like, yeah, he can have it or she can have it. It's just as long as we get the same amount of stuff, right? If the trust or will says you have to sell the property, that becomes more difficult. And the other thing is, if you require the sale at a certain period of time or at all, it takes discretion and control away from the executor trustee. This person that you trust, that you've put in place to help manage these assets and distribute things to the beneficiaries, that takes a lot of power out of their hands to make the best decision for the best interests of the beneficiaries. So I'm not a huge proponent of saying, well, sell the property within this period of time, or you have to sell the property. I don't like that. I usually leave it vague so that the trustee can have some discretion and make that decision that's the best decision for the beneficiaries. Another thing to consider with regard to your real estate, and this is for people that own multiple pieces of real estate in different states, estate planning and estate tax laws vary from state to state, and they have their own inheritance laws, they have their own estate laws, their probate processes are different. And so if you have multi-state ownership, you want to make sure that you consider that as part of your estate plan. So if you own properties in multiple states, if you own property in Washington, maybe you live in Washington, but you have a place in Arizona or a place in Idaho or Oregon or wherever, right? And so if you have properties in multiple states, you really need to consider this, because if you own these properties in your name, the requirement is going to be that you're going to have a probate in Arizona and a probate in Washington, or a probate in Idaho and a probate in Washington. And that's foreign for your kids or your trustee probably, right? And so a will plan in that situation is probably not right for you, because a will is going to go through probate. The typical plan that I recommend in that situation is to do a revocable trust as your main estate document, because as long as the properties are owned in the trust, that property in Arizona and the property in Idaho and the property in Washington, as long as they're owned in the trust, determines how they're distributed. And so they're not going through probate in some foreign state that your kids don't know about, or your beneficiaries don't know about, or your trustee or executor don't know about, okay? And they don't know lawyers down there, and they can't get recommendations. Is a lot more difficult, okay? And so that unfamiliarity is a huge thing. The added expense of having to do multiple probates is a big thing. And so if you have multiple properties, you really need to think about it. You really need to work with an estate planning attorney and come up with a plan, typically a trust plan, to avoid having multiple complex probates going on at once. Another thing to consider with regard to income producing properties. So we talked about a maintenance and management plan. We want to make sure that the ongoing management of these income producing properties is sort of dialed in, and that this continuity of management continues when you're gone. So that's why it's often a good idea to have a property management company involved to sort of do the day-to-day. Because if your dad is years old and he's managing all the rentals by himself, which happens, and I have clients that do it, and they pass away, it's much more complicated to get rent collected and keep tenants happy and make sure you're getting paid, right? Make sure the upkeep's good. And the other thing to consider too, once you passed away, is if you have rental properties and you're keeping them, we want to make sure that the income from those rental properties is properly distributed among beneficiaries. And so how to do that is important. And making sure that these investment properties are still profitable for your beneficiaries is important. And so you should have clear instructions in that regard within your estate plan. And then finally, something to consider is how the market fluctuates. So beginning of the episode, we talked about how in the last 4 years or so, property values in Washington State have gone up. The median home price in Washington State, I should say, has gone up 46 since 2019, which is a ton. It's huge, right? And so that market changes a lot. When I was looking at what that market value did over the last few years, because I knew it has gone up, right? Since the COVID pandemic in particular, in the mid 2000s, like 2008, 2009, 2010, those were negative numbers, right? Those years were negative in property value, in Washington. So they went down during those years. So real estate markets can be volatile, and that affects your estate, right? And so you want to make sure that your estate plan is up to date. Maybe take a look at it every few years. I say every couple of years, look at your estate plan, 2 to 5 years or major life events. And that's the other thing too. We were talked about in liquidity. If you don't have liquidity, then you have problems potentially with your estate plan when you pass and paying bills and taxes and all that stuff. So diversification might be important. I'm not a financial advisor, so I wouldn't say, you should also have stock. I don't know, or other kinds of assets. But having just real estate, as far as an investment strategy, isn't always the best thing. You might want to have some diversity in your investments. Like maybe just use CDs if you don't like the stock market, right? Money market. There's lots of different ways to make money. So consider that probably. If you're real estate heavy, maybe diversify a little bit. And so by addressing these considerations that we've talked about, you can create a comprehensive estate plan that accounts for the complexities of owning multiple properties. And this ensures that your real estate assets are managed and distributed according to your wishes, which provides you peace of mind, right? And makes your beneficiaries happier than if you had not done these things. So that leads us up to story time. And I've got a couple stories. I have a lot of clients that have multiple real estate holdings. And so the first one is a couple that has multiple properties in multiple states, and they have multiple different kinds of entities. So they've got properties here, they've got properties in Oregon, they've got properties in Hawaii, and they hold these entities in LLCs. And so their estate plan goes through who gets what and how they're managed later, right? They've set up specific plans. So we've covered the ownership, we've covered the property management plan, we've covered the value of these properties and how that impacts their taxable estate. And so by having those things dialed in with a clear plan, and they basically centralize the holdings of their assets too with the family LLC. And so that allows the family LLC to sort of hold multiple properties or multiple other entities potentially in order to simplify an estate plan and distribution process where there's lots of different properties. And so they've really done a good job making sure that their beneficiaries are in the loop for one, and that they're taken care of because they have their properties sort of dealt with. They won't have to go through multiple probates. They have asset protection through LLCs. And so they've really done a good job in being proactive with regard to their estate plan. And the second story I wanted to show is a story of two siblings. Their mom had a piece of real estate, one house. She was real estate heavy because she didn't have a lot of assets. Her main asset was her house. And the two siblings wanted to make that house a rental. And so they, instead of distributing it to themselves individually, what we did is we set up a real estate limited liability company that held that real estate, and they each owned 50%. They had a renter in there that paid rent for many years, and they shared the profits, right? They shared the proceeds from the rent. And then when they decided they didn't want to keep the property anymore, the LLC sold the property and they split the proceeds. And so while their mom didn't have a clear plan other than give this property to my kids, after the fact, we set up this LLC, which maintained and managed that rental for their benefit for as long as they wanted to, right? So their mom said, give everything to my kids, but she didn't say, well, you have to sell this house and then split the proceeds. She gave the executor the discretion to make that determination, and the kids made that decision themselves. And so when I say kids, I say adults that are children of a deceased person. They made that decision themselves and thought, well, we want to keep this house as a rental, and we thought the LLC would be the best way to do it because then you have the asset protection that you would like. You have an easy management structure between the two beneficiaries, and everything can be above board and everybody's happy. So that was a good experience using LLCs as part of the estate plan, having a management plan sort of devised after the fact, and making sure the property is sort of taken care of under the parameters of that LLC and what the beneficiaries wanted to do. So that was a success. So that leads us to our something good in the news segment. And I really think this is a good story. So this is from the AP. Harare, Zimbabwe, from the AP, Associated Press. After her son, the family's shining light and only breadwinner, was arrested last year, Tembudzai Tembo went into meltdown. In Zimbabwe, where clinical mental health services are scarce, her chances of getting professional help were next to zero, and she contemplated suicide. I didn't want to live anymore. People who saw me would think everything was okay, but inside my head was spinning, the 57-year-old said. I was on my own. A wooden bench and empathetic grandmother saved her. Older people are at the center of a homegrown form of mental health therapy in Zimbabwe that is being adopted in places like the United States. The approach involves setting up benches in quiet, discreet corners of community clinics and in churches, poor neighborhoods, and there's one at a university. An older woman with basic training in problem-solving therapy patiently sits there, ready to listen and engage in one-on-one conversation. The therapy is inspired by the traditional practice in Zimbabwe, in which grandmothers were the go-to people for wisdom in rough times. It had been abandoned with urbanization and the break of tight-knit extended families and modern technology, but now it's proving useful again as mental health needs grow. Grandmothers are the custodians of local culture and wisdom. They're rooted in their communities, said Dixon Chibanda, who's a psychiatry professor and founder of the initiative. They don't leave, and in addition, they have an amazing ability to use what we call expressed empathy to make people feel respected and understood. Last year, Chibanda was named the winner of a $150,000 prize by the U.S.-based McNulty Foundation for revolutionizing mental health care. Chibanda said the concept has taken root in places like Vietnam, Botswana, Malawi, Kenya, Tanzania, and in preliminary formative work in London. It's also gained ground in places like New York City and Washington, D.C. And so I thought that was a pretty good story this week. You know, it's always nice to have someone that maybe knows a little bit more than you, maybe has a little bit more life experience than you to bounce ideas off of. And I think with the multi-generational households basically gone away in this country and we're all sort of living separate, it's nice to see that we're trying to pull back some of that old way that we had, right? Talking to our grandparents, talking to our elders for advice in hard times. And so I think more of that is a good thing. Anyway, that's the end of our episode. I hope you enjoyed it this week. Thanks for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.